So suppose we were to decide this case in your favor without reaching some of the agencies that have been mentioned, like the tax court and the claims court and the Court of Appeals for the Armed Forces, to name three. Suppose we were to decide the case in your favor, but we did not want to address those other agencies. On what ground, one way or the other, to express a view that would affect those agencies either, as I said, one way or the other? On what would you propose that we say so as to reserve decision on those agencies that may not come before?
Watch Samuel Alito lean forward with that particular reptilian energy he reserves for moments when the mask slips entirely off, and understand what you just witnessed, because this is not merely legal procedure or constitutional interpretation or some tedious technical question about administrative law. This is nakedly the architecture of authoritarianism being constructed in real time on the highest bench in the land, with the cameras rolling and the transcript documenting it for posterity, while we sit here watching a Supreme Court justice literally strategize with the attorney representing a wannabe autocrat about how to craft a ruling that guts federal agencies while preserving just enough plausible deniability to avoid the political backlash they know is coming. Justice Sonia Sotomayor didn't mince words when she told Trump's lawyer he was asking the court to destroy the structure of government, and she was absolutely correct, because that is precisely what this is, a methodical demolition project dressed up in the robes of jurisprudence, and Alito sitting there asking Trump's Solicitor General how they might rule in his favor without addressing certain agencies is the equivalent of a judge asking a defendant's lawyer how to write an opinion that gets them off while leaving room to prosecute their enemies later. It is procedural corruption masquerading as judicial restraint, and it reveals the entire conservative legal project for what it has always been, which is not about originalism or textualism or any of the high-minded constitutional principles they wrap themselves in, but rather about concentrating power in the hands of their preferred political faction, while dismantling every institutional check that might constrain that power. This is unitary executive theory, metastasizing into something even more dangerous than its architects initially imagined. And make no mistake, what you're watching is the logical endpoint of a decades-long campaign that began in the Reagan administration, when conservative legal theorists started spinning this fantasy that Article 2 of the Constitution gives the president essentially monarchical control over the entire executive branch, the theory that the Constitution gives presidents complete control over executive functions, which must include the power to remove commission members. And what was once a fringe position debated in law school seminars has now become the operational framework for a Supreme Court majority that includes 3 Trump appointees specifically selected for their commitment to gutting the administrative state. The Supreme Court appeared likely to allow President Donald Trump to remove a Democratic member of the Federal Trade Commission purely for policy reasons, rolling back 90 years of legal precedent in a decision that would expand presidential power and could transform the federal government and effectively end the independence of some 2 dozen bipartisan agencies that Congress had designed to be insulated from political interference. And here's what should terrify you about that particular formulation, because we're not talking about some abstract constitutional theory anymore. We're talking about dismantling the fundamental architecture of expertise and nonpartisan administration that has protected Americans from corporate predation and environmental catastrophe and financial collapse since the New Deal. The Supreme Court is at war with the administrative state, and that language of warfare is not hyperbolic. It's diagnostic, because this is a coordinated multi-front assault that includes the overturning of Chevron deference in a maximalist decision that went further than even the most ardent opponents thought possible. That includes the major questions doctrine, which provides that courts will presume Congress does not delegate issues of major political or economic significance to administrative agencies without a clear statement to that effect. That includes stripping agencies of their ability to conduct in-house enforcement proceedings, and now this the crown jewel of the project, which is eliminating the independence of multi-member commissions so that every regulatory body from the FTC to the SEC to the NLRB to the Nuclear Regulatory Commission becomes an extension of presidential whim subject to purges whenever the White House changes hands or whenever a commissioner's policy views deviate from the president's political imperatives. All 6 of the Supreme Court's conservative justices indicated that a president should have absolute control over the leadership of any government body carrying out executive functions, such as rulemaking and law enforcement. And let that sink in for a moment, because what they're describing is not a republic of laws and balanced powers, but rather an executive branch that functions as the president's personal fiefdom, where expertise and independence and institutional memory all become subordinate to the political priorities of whoever won the last election. The sheer cynicism of Alito's question should make your blood boil, because he's essentially asking how can we hand Trump this victory while creating enough ambiguity to protect certain agencies we care about from future Democratic presidents. How can we make this ruling look narrow and judicious while in fact demolishing the entire framework of independent regulation? And justices suggested some limitations on the president's removal powers, especially as it relates to the Federal Reserve, noting it as a uniquely structured quasi-private entity, which reveals the game completely, because they're admitting that independence matters. They're admitting that insulating certain functions from political interference serves vital purposes, but they're willing to sacrifice that principle everywhere else, because the conservative movement has spent 40 years building toward this moment of regulatory rollback, and they're not going to let a little thing like institutional stability or separation of powers or the lessons of history stand in their way. Chief Justice Roberts called Humphrey's executor a dried husk, arguing that the FTC of 1935 wielded very little if any executive power compared to the muscular agency that exists today, which is precisely backwards logic, because the fact that these agencies have grown more powerful and more complex and more technically sophisticated is exactly why they need independence from political interference, not less. You don't solve the problem of concentrated regulatory power by making it answerable to concentrated executive power. You solve it through accountability mechanisms and transparency and congressional oversight, not through presidential purges. Justice Elena Kagan warned that the administration's position would give presidents massive unchecked, uncontrolled power, enabling them not only to oversee executive functions, but to dominate policymaking and adjudication, and concentrating so much authority in the White House would let a president sweep aside nonpartisan experts by having a president come in and fire all the scientists and the doctors and the economists and the PhDs, and replacing them with loyalists, which is not in the best interest of the citizens of the United States. And this is what makes the liberal justices' dissent so crucial, because they're not engaging in abstract legal theorizing, they're describing the concrete human consequences of what happens when you subordinate expert judgment to political loyalty, when you make every environmental scientist's job dependent on whether they reach conclusions the president likes, when you make every financial regulator's career contingent on whether they're sufficiently deferential to Wall Street when the administration wants to deregulate, when you make every labor board member vulnerable to firing the moment they rule in favor of workers over corporations, if that conflicts with the president's donor base. And let's talk about what this means in practice, because Trump has already shown us the playbook, and it's even more expansive than traditional unitary executive theory would suggest. He has impounded funds, dismantled agencies, fired government officials, appointed special government employees with sweeping powers, altered constitutional amendments, and purported to end the independence of certain agencies, all in contravention of existing law. He issued an executive order, which would effectively end the independence of all executive branch agencies, including the Federal Trade Commission, Securities and Exchange Commission, Federal Election Commission, National Labor Relations Board, and even most functions of the Federal Reserve, FUNG, and the administration believes the Supreme Court has already remade the presidency and blessed their actions despite laws and legal precedents in its decision in Trump v. United States, which granted him criminal immunity for official acts. So what we're seeing is a theory of executive power so capacious, so unbound by constitutional limits, that it encompasses not just the ability to fire officials, but the ability to direct prosecutions, to impound congressionally appropriated funds, to disregard statutory mandates, to essentially nullify the legislative branch's ability to constrain executive action through law. The historical parallels should be obvious to anyone paying attention, because this is exactly how democratic backsliding happens, not through dramatic coups but through the steady erosion of institutional independence, through the politicization of previously nonpartisan bodies, through the concentration of power in the executive, coupled with a compliant judiciary willing to bless each incremental power grab. And conservatives have spent decades deliberately undermining the social democratic and regulatory state in an attempt to reset the clock as part of a decades-long highly successful war by the political right to dismantle the mild regulatory and social democratic state that developed following the New Deal and revive private elite wealthy and white control of society and the economy. This is the long game of the conservative legal movement finally coming to fruition, with a Supreme Court majority willing to overturn 90 years of precedent, willing to ignore the will of Congress, willing to hand the president powers the framers would have recognized as monarchical, and they're doing it while claiming to be originalists, while claiming to be faithful to constitutional text, while claiming to be defending separation of powers, when in fact they're eviscerating all of those principles in service of a reactionary political project. What makes this moment particularly dangerous is the intersection of several concurrent crises in American constitutional democracy, and you have to understand how they reinforce each other. You have the overturning of Chevron deference, which will have an immediate and lasting impact on executive, agency interpretations of ambiguous federal statutes, as well as potentially on hundreds if not thousands of prior decisions decided on Chevron deference grounds, and the future of the administrative state in America. You have a tsunami of lawsuits against agencies that will follow from coupling corner post with Loper Bright, meaning that even decades-old regulations can now be challenged outside the statute of limitations if someone can claim recent injury. You have the major questions doctrine, which allows this Supreme Court to veto any regulatory action they deem sufficiently significant, by claiming Congress didn't explicitly authorize it. And now you have the demolition of independent agency protections, which means that every 4 or 8 years, when the presidency changes hands, you'll see wholesale purges of commissioners and regulators and technical experts replaced by political loyalists, which will make it impossible to maintain any kind of regulatory consistency or institutional memory or long-term planning in areas like financial stability or environmental protection or nuclear safety. The clip you just watched is Alito revealing the game because he's not asking a neutral procedural question. He's coaching Trump's lawyer on how to craft a victory that doesn't immediately trigger maximum political resistance. He's essentially saying, look, we want to give you this, but we need you to help us figure out how to do it without making it so obvious that we're just handing the president dictatorial powers over the administrative state. Alito said the lawyer needed to explain more concretely the limits of his own argument, because you can't make the argument that the logic of the president's position will cause revolutionary results without being prepared to explain where your own argument stops, which is rich coming from someone who's about to vote to overturn 90 years of precedent in service of revolutionary changes to the structure of American government. But it reveals the anxiety. They know this is radical. They know this is destabilizing. They know the consequences will be profound, and they're looking for ways to do it incrementally to preserve some fig leaf of judicial minimalism, while in fact engaging in maximalist constitutional revision. Trump has expanded his control over executive branch agencies, ordering many of them to target his political opponents and organizations aligned with the Democratic Party, and his administration has asserted that under the unitary executive theory, it had a constitutional right to control and even cease enforcement of federal law, which legal experts described as claiming a constitutional power to immunize private parties to commit otherwise illegal acts with impunity, and Trump and his subordinates have been described as embracing some of the theory's most extreme versions. And this is what happens when you combine an authoritarian temperament with a Supreme Court willing to constitutionalize that authoritarianism. You don't just get enhanced executive power, you get executive power weaponized against the rule of law itself, power used not to faithfully execute the laws, but to selectively enforce them, or not enforce them, based on political convenience, power used to protect friends and punish enemies, power used to restructure the relationship between government and corporate interests in ways that serve the wealthiest and most powerful. The implications for climate policy alone should be enough to mobilize massive resistance because at every stage of the regulatory process, the Supreme Court has set up obstacles to agencies issuing rules to implementing those rules, and even to enforcing them, and routine penalty assessments that agencies do through in-house tribunals, now in many instances require a jury trial, which means it's harder for agencies to regulate, and when you combine that with the ability of a president to fire any EPA official, or any energy regulator, or any climate scientist who produces research or promulgates rules that conflict with the administration's fossil fuel-friendly agenda, you've essentially made it impossible to address the climate crisis through regulatory action, which means we're locked into a trajectory of civilizational catastrophe because 6 unelected judges decided that the fiction of unitary executive power matters more than the survival of organized human society. This is not hyperbole. This is the literal consequence of preventing agencies from regulating carbon emissions, from enforcing clean air standards, from setting fuel efficiency requirements, from doing any of the things necessary to prevent runaway climate change. And consider what this means for financial regulation, because the outcome will determine whether there will be any Democrats left on the FTC or other regulatory bodies, and whether any of the other independent agencies will be truly independent any longer, and the case could transform the federal government and effectively end the independence of some 24 bipartisan agencies that Congress had designed to be insulated from political interference, which means the next time a Democratic president wants to crack down on Wall Street excess or tech monopolies or corporate fraud, they'll have the authority to do so by firing Republican commissioners and replacing them with progressives, but it also means the next time a Republican president wants to deregulate the financial sector or let big tech run wild or turn a blind eye to corporate malfeasance, they'll have that same authority. And anyone who thinks this creates some kind of neutral expansion of presidential power that progressives can use when they're in office is deluding themselves because the asymmetry is baked in. Conservative judges will always be more willing to uphold Republican assertions of unitary executive power than Democratic ones, and the underlying project here is not about enhancing executive authority in the abstract, it's about neutering the regulatory state permanently by making it subject to political capture and reversal every election cycle, which makes long-term regulation impossible and serves the interests of precisely those corporate actors who benefit from regulatory instability and who have funded this legal movement for decades. Trump's legal team has fully embraced the unitary executive theory, which asserts that the president has the exclusive authority under Article 2 of the Constitution to exert executive power, including making regulatory decisions, and Trump has fired without cause members, not just of the FTC, but also many other agencies that have power over vital health, safety, labor, and environmental issues, including the Consumer Product Safety Commission, the Surface Transportation Board, and the Equal Employment Opportunity Commission. And these aren't abstract bureaucratic reshufflings. These are agencies that determine whether your car is safe, whether your food is contaminated, whether your workplace will kill you, whether your kids' toys contain lead, whether your drinking water is poisoned, whether airlines maintain their planes, whether railways inspect their tracks. These are the unglamorous but absolutely essential functions of modern governance. And Trump is purging them of anyone who takes those protective missions seriously, and replacing them with people whose primary qualification is loyalty to him, and the Supreme Court is about to tell him that's perfectly fine. That's what the Constitution requires. That's what presidential accountability demands. The language that keeps appearing in the conservative justices' questions is accountability, and it's such a perfect Orwellian inversion because what they mean by accountability is making regulatory agencies answerable to the president, which actually makes them less accountable to the public, less accountable to Congress, less accountable to law, less accountable to expertise, and more accountable only to the political imperatives of whoever occupies the White House. Justice Kavanaugh said these officials are not elected as Congress and the president are, and are exercising massive power over individual liberty and billion-dollar industries, which sounds like a democratic critique until you realize that making them fireable by the president doesn't make them more democratically accountable, it just makes them more politically vulnerable. The whole point of independent agencies was to create spaces where decisions could be made based on evidence and expertise and law, rather than based on who the president's donors are, or what the president's poll numbers need, or which industries the president wants to favor. That's not anti-democratic. That's how you preserve democratic governance in a complex technological society where most crucial decisions require specialized knowledge and long-term planning, horizons that exceed election cycles. The unitary executive theory is a fancy way of saying that a chief executive can rule over the executive branch like a monarch, and every one of its millions of employees serves at the president's beck and call. And that formulation captures perfectly what's wrong with this entire project, because the framers didn't fight a revolution against monarchy in order to create an elected monarchy. They created a republic with dispersed powers and institutional checks and separations designed specifically to prevent any single person or faction from accumulating the kind of power that Trump and his enablers on the Supreme Court are now trying to concentrate in the presidency. Chief Justice Roberts wrote that the president is the only person who alone composes a branch of government, to which Justice Sotomayor responded, in every use of official power, the president is now a king above the law. And that wasn't in the context of this case, that was in the immunity decision, but it's the same underlying logic. This court is systematically removing every constraint on presidential power, removing criminal accountability through the immunity doctrine, removing congressional constraints through aggressive unitary executive readings, removing judicial oversight through the gutting of Chevron, and the major questions doctrine, removing agency independence through this case, and what you're left with is something that looks much more like an autocracy than a republic. The question that should haunt us is why now? And the answer is that this has been building for decades, but it's reaching fruition now because the conservative legal movement finally has the Supreme Court supermajority it needs to implement its full agenda, because Trump's authoritarian instincts align perfectly with the movement's institutional goals, because the Republican Party has completed its transformation into an anti-democratic party willing to embrace minoritarian rule, and because the traditional guardrails of American democracy have been so degraded that there's no longer an effective check on judicial overreach. Just in the month of January, the court took 3 significant steps towards the effective dismantling of the administrative state, and that is a fast pace, and the court is not relying on passive virtues to avoid confrontations with the other branches, which was written back in 2022. And if that was the pace, then imagine the pace now. Imagine the velocity of constitutional demolition when you have a court this radicalized, this committed to a reactionary project, this unconcerned with precedent or institutional legitimacy, this willing to engineer outcomes that happen to align perfectly with the preferences of the most powerful corporate and financial interests in the country. And we need to talk about Alito specifically because this is the same justice who was caught on tape saying the nation should return to godliness, the same justice whose wife flew insurrectionist flags at their properties, the same justice who has refused to recuse himself from cases involving January 6th despite obvious conflicts, the same justice who in his confirmation hearing seemed to endorse a weaker version of the unitary executive theory, but has since become one of its most aggressive proponents, and watching him strategize with Trump's lawyer about how to craft a ruling that guts agencies while preserving flexibility reveals everything you need to know about how he approaches his role, not as a neutral arbiter of law, but as a participant in a political project, not as someone applying precedent, but as someone engineering outcomes, not as someone constrained by judicial norms, but as someone wielding judicial power in service of an ideological agenda. And the fact that he's doing it openly on the record in oral argument shows how confident he is that there will be no accountability, no consequences, no institutional pushback, because the court's legitimacy has already been so compromised that one more outrage barely registers. There is grave danger in what the Supreme Court appears willing to do, handing giant corporations and Trump's billionaire-class unchecked power over our economic system, gutting one of the few institutions left that's charged with ensuring fairness, stability and competition in our economy, because for generations independent federal agencies, including the Federal Trade Commission and the Federal Reserve, have proven essential to the long-term stability of our country and markets, all to the benefit of workers, consumers, and businesses alike. And this captures the stakes with perfect clarity, because what's being dismantled here is not some abstract constitutional principle, but rather the practical institutional infrastructure that prevents corporate domination, that maintains some minimal level of fairness in markets, that protect consumers and workers, and the environment from pure profit maximization. And the beneficiaries of this dismantling are obvious. They're the corporations who don't want strong FTC enforcement of antitrust law. They're the financial institutions who don't want SEC scrutiny of their practices. They're the polluters who don't want EPA regulation. They're the labor exploiters who don't want NLRB protection of organizing rights. And the conservative legal movement has spent 4 decades building the intellectual scaffolding to justify giving those interests exactly what they want, while claiming it's what the Constitution demands. What's so insidious about this moment is how it's being framed as a debate about constitutional interpretation, rather than what it actually is, which is a raw power grab disguised as jurisprudence. And every time a liberal justice points out the catastrophic consequences, Roberts or Alito or Gorsuch responds with some formalist argument about constitutional structure or textual interpretation, as if the question were really about what Article 2 means, rather than about who will have power in American society going forward. Justice Gorsuch said Humphrey's executor was poorly reasoned and suggested there's no such thing in our constitutional order as a fourth branch of government that's quasi-judicial and quasi-legislative, referring to the idea that independent agencies do not fit within any of the 3 branches of government defined in the Constitution, which is such a perfect example of formalist reasoning used to reach a predetermined outcome, because the framers also didn't envision administrative agencies or the modern regulatory state at all. They didn't envision the EPA or the SEC or the FTC or any of the institutional mechanisms we've developed to govern a complex industrial democracy. But somehow that doesn't prevent Gorsuch from having strong opinions about how those agencies should be structured in ways that conveniently align with the preferences of the Federalist Society donors who funded his career. This is the Federalist Society's finest hour, and we should understand that clearly, because every single conservative justice on this court is a product of that movement, has been vetted by that movement, has been groomed by that movement to reach exactly these conclusions. The makeup of the court itself reflects the war on the administrative state, with the Trump administration having specifically selected judicial nominees, in part based on their hostility to the federal bureaucracy, and the Supreme Court's conservative majority includes 3 Trump appointees, Gorsuch, Kavanaugh, and Barrett. This is a decades-long project finally reaching maturity with a court stacked precisely to deliver these outcomes, with justices selected precisely because they could be counted on to dismantle the regulatory state, while claiming they're just calling balls and strikes. And the genius of the project has been wrapping these power grabs in the language of constitutional principle, in the rhetoric of originalism and textualism, in the performance of neutral judging, when in fact every major decision by this court's conservative majority advances the same substantive agenda of empowering corporation, constraining government, and concentrating power in Republican executives. So when Alito sits there asking how they can rule for Trump without addressing certain agencies, understand what you're watching, which is a justice trying to figure out how to engineer a maximally destructive outcome while preserving enough ambiguity to deflect criticism, trying to dismantle independent agencies while claiming to exercise judicial restraint, trying to hand Trump authoritarian powers while maintaining the fiction that this is just neutral constitutional interpretation, and the tragedy is that he's probably going to succeed because the conservative majority has the votes, and they've already signaled through their emergency orders allowing these firings to proceed that they're prepared to overturn or eviscerate Humphrey's executor, and when that happens, when the decision comes down, probably in June, probably in a 6-3 ruling, probably with Roberts writing some opinion that tries to sound minimalist, while in fact revolutionizing the structure of American government, we need to understand that this was a choice. This was a political project implemented through judicial means. This was the conservative legal movement, achieving through courts what it could never achieve through democratic politics, which is the wholesale dismantling of the regulatory state and the subordination of expertise to executive power and the elimination of institutional independence as a constitutional value, and we need to respond accordingly, not by treating this as normal judicial business, but by recognizing it as a crisis of constitutional democracy that demands transformative responses, including court reform, including democratic resistance, including a fundamental rethinking of how we preserve the capacity for effective governance in a society where 6 unelected judges can veto the will of Congress and empower authoritarianism and hand corporations the deregulated paradise they've been dreaming of for a century.